So good evening and welcome. My name is Debbie Moore. I'm part of the team at Advisors with Purpose. It's my pleasure to welcome you, to thank you for joining us, and to thank Opportunity International Canada for inviting you. So we're going to jump right into tonight's webinar, Estate Planning in Life's Second Chapter, and looking after your estate. So it's definitely a great topic, but it's right now my pleasure to introduce Stephanie Joseph. Stephanie is part of the team at Opportunity International in the Donor Relations Department. She's going to bring a few words, let you know about some of the great work that they're doing, and just then she'll introduce our speakers. So Stephanie, over to you.
Thank you. Thanks, Debbie. Well, welcome everyone. Thank you for being with us here tonight. My name is Stephanie Joseph, and I serve as Philanthropy Officer and Donor Relations at Opportunity International Canada. And I'm joining you tonight from London, Ontario. I'm stepping in for our CEO, Dan Murray, who is traveling today. He sends his greetings to you. I want to welcome all of you from around the country who are here to learn more about estate planning, wills, and planned giving in life's second chapter. And I'm cheering for each of you this evening. You have put planning for your future and considering those dearest to you as a priority this week. At Opportunity, our mission is to see people empowered to work their way out of poverty with dignity and with purpose. It is with so much joy to share that thanks in part to your generosity, along with many others like you, Opportunity International Canada was able to directly and indirectly impact over 3.1 million people in 2023. 3.1 million people. It's incredible. Thank you for your part in the cycle of transformation for our clients and their families and communities. We have witnessed the transformative power of providing enterprising women and men access to capital and financial services in the forms of microloans, training, and support along their journey to enable them to work their way out of poverty, as well as working to end the global education crisis by addressing barriers to quality education. Investing in innovative digital platforms that allow us to reach more clients faster and at a lower cost, and investing in at-risk youth, women farmers, and entrepreneurs, as we are doing in Ghana. We are seeing individuals build better lives for themselves and change the future for their families for generations to come. Lives are transformed when people, especially women, gain stable sources of revenue and can in turn invest that into their families by providing nourishing food, being able to keep their kids in school, have access to healthcare and medication, and so much more. Our incredibly hardworking, resilient, creative, and brave clients benefit greatly from the generosity of donors like you. As a way to thank you for your partnership that allows this work to happen, as well as to provide a service that may be of benefit and blessing to you and your loved ones, this is an opportunity for us to give back to you tonight. We've been working with Advisors with Purpose, or AWP, for over a decade now, providing free information and webinars on estate planning, wills, and legacy giving. I am so thrilled to introduce you to Lauren Jackson, an expert in this field, and his colleague, Mary Lynn Huizinga. Tonight, they're going to walk us through several important topics. I truly believe this time will be beneficial to you, and you will take away many things to consider, questions to ask, or next steps. If you haven't yet got your notepad and pen in front of you, please take a moment to do that now. At the end of Lauren and Mary Lynn's presentation, I encourage you to take advantage of the question time. As Debbie shared with us, you will also have a chance following the webinar to speak directly with an AWP estate specialist. And now I'll pass it over to Lauren Jackson, the president of Advisors with Purpose.
Well, thank you, Stephanie, and thank you all for joining us. It's great to have you with us and be able to connect. And I love what Opportunity International does. I got to tell you, I think I'm been quoted around their office. I call it's a no-brainer. I mean, when you can teach a person how to fish rather than just give them a fish, you're changing generations. And I've been on some of their insight trips in other countries, and I love what they do. That's just a little plug for them, but that's not what I'm here for. That's not what I'm here to do. So let's get started on this. Taking care of your estate in the life's second chapter. Yeah, sometimes I say, you can tell by the look of this old guy that I'm in the fourth quarter of the game. And of course, when you're talking football, the fourth quarter, you have to sometimes change the way you play the game. So that's how I feel sometimes. But I think it would be good. I've been in the financial services for over 40 years, a long time in that area. And when I sold my for-profit business way back in 2001 and left there, I became what I call rewired. I didn't retire, I just got rewired, and I volunteered my time to do this kind of thing that I'm doing today. But that's me. Who is Advisors with Purpose? Well, it's a ministry arm of Financial Discipleship Canada. That's a charity that we have registered called Financial Discipleship Canada. And this is how we do ministry. And then we partner with charities across Canada and offering estate planning services to you, their donors. And we don't sell anything. So you never have to worry that we're going to try to sell you something. That's not what we do. We're not licensed to try to sell you something. And we're not lawyers, so we don't do your will. Now you may be thinking, well, I thought that's what this was. Well, kind of, but we're not talking about doing wills here. We're going to talk about a plan for your will. But here's the most important bullet point on this screen. There is no cost to you for this service. I know what you're thinking. You don't sell anything and there's no cost. What's the catch? Well, there is no catch, because Opportunity International, as Stephanie said, has been with us for over 10 years, and they pay a retainer to provide this service to you, their donor. Why would they do that? I know exactly why they do it. It's their way, as Stephanie even said, it's their way of saying thank you back to you for your support of Opportunity International. So as I go through this, if this can be of any help to you at all, why not take advantage of it? Because there is no cost. It doesn't change their cost. So yeah, let's do that. So here's why we do this. The first reason is that over half of Canadians don't even have a valid will. Some of them may not even know that it's not a valid will, but that's of great concern, and that's a stat from the Government of Canada. Here's another one. According to Forbes magazine, who did a survey back in 2018, 70% of estate transfers, in other words, the person has passed away, their will has kicked in, 70%, 7 out of 10 of those fail to meet the objectives of those who left it behind. And we know that because the vacation property they thought they were going to get, the kids were going to get, ended up having to be sold to pay the capital gains tax, or their RRSP that they thought they were going to be giving to their kids, half of it got eaten up in tax. Those are the reasons we know, or maybe the kids are fighting over something. So it just wasn't clear. And we would like to help you prevent that kind of thing happening. So when we graduate to heaven, there's really 3 ways to transfer our assets at the end of life. The first one is through beneficiary designation. So if you have an RSP or a TFSA, tax-free savings account, you would already have a named beneficiary on it. If you have a spouse, it's probably your spouse. If you may have life insurance with a named beneficiary, or segregated funds. By the way, that's just a mutual fund that is invested and managed by a life insurance company. They actually have named beneficiaries. So if you have an opportunity to put a named beneficiary on it, do that. That's a great way because it's direct. There's no probate. There's no issues. Next one is joint ownership. So joint ownership of your house, joint ownership of your bank accounts. And we're going to talk a little bit later on in my part of this session about joint ownerships, and we'll help clarify maybe some questions about that. But those are a good way to pass assets as well. And that again passes outside of the will, is not part of the estate for probate issues, all those kind of things. But there is a risk. There can be a risk. And the risk would be, if it's your spouse, then that's fine. But if you're making your children or a friend of yours that you want to pass these assets to at the end of your life as a joint owner on something, well, that might have a risk. Because if you made your child a joint owner of your bank account, they could withdraw money from it. Or maybe not even withdraw money, maybe they just use the cash in your account as a collateral for a loan. Now, if for some reason they didn't pay off their loan, then they're going to come taking your bank account. So there are risks there. Also, sometimes I get asked, well, maybe I should transfer my house to my child for part ownership or full ownership, whatever. No, that would be a really bad idea. And the main reason is tax issues. It's not your child's primary dwelling. So when the child sells it at some later date, even if you're already gone, then it's going to be taxable. The gain on it will be taxable to them. So keep it in your name, because if you're living there, then it's your primary dwelling and it's tax-free. Good thing. But everything else, so 3 ways, everything else goes through your will. So if you have anything that you can't name as a named beneficiary, like mutual funds, stock portfolio, those kind of things, then you need a will to transfer those. Joint ownership on your house, that's fine. But if you have other property and maybe it's in joint ownership with one of your children or another business owner, then we'll talk a little bit about that in a moment. Here's my favorite way, actually. And I think you could call it the 4th way to transfer assets, and that's by cash. Do it now. Yeah, so if you have enough, how much is enough? That's a great question to research, by the way. How much is enough to retire on? Many times we just keep building more and more and more, and no thought given to how much is enough. How much is enough to leave my family? What's the right amount to leave to my kids without destroying them or causing them to not want to work anymore because they got so much money, or driving a wedge between a husband and wife? We obviously don't want to do that. And then how much would I want to give to charity? If I was going to give some to charity, what percentage of my will should I give to charity? So those are good questions to ask. But you know what? Maybe you have more than enough and could start to give it away now. I always encourage people to give it away now, because that removes the tax aspect from it. You can give as much to your kids as you want now, and there is no tax issue to do that, as long as it's not, you know, an investment that's got a whole bunch of capital gain in it. Then that's another issue, and that's where we can help you. But yeah, giving cash, etc., GICs away to kids or charity now, good thing. My wife and I decided to help our kids while they were raising my grandkids, and help them with mortgages and so on, and they're debt free. But it was a deal where we shared the payment of those things with them so that they could then have our grandkids educated and proper schools and so on. So anyhow, that's just us. So if you're going to give to charity, then the question comes, well, what if I wanted to give to charity? What would be the best assets to give? That's a very good question, and one that we should all think about, because there's a very big difference on what assets I would give. And I'm going to talk to you just in a moment here about RRSPs and RIFs. That's one of the things that we need to talk about. So here we go. So what about planning well for your RSP or RIF? What does that look like? Well, the first thing, I want to put a disclaimer here at the bottom corner. It says Quebec. There is no beneficiary on your assets like this, except if it's through a life insurance company. So if your RSP is with a life insurance company, then you could have a beneficiary on it. But if it's down at the bank or somewhere else, mutual fund company, then that's not the way they do things in Quebec. But the rest of us, I'm in Eastern Ontario, so yeah, so we fall under these RRSP rules in the States. So what are the rules? Well, it's fully taxable to the estate unless it's to a qualified beneficiary. This is Canada Revenue Agency rules. A qualified beneficiary. What's a qualified beneficiary? I'm glad you asked. Your spouse is a qualified beneficiary. A financially dependent child or grandchild. In other words, a disabled child or grandchild. Now, if they're under the age of 18, of course, they're financially dependent. If they're over the age of 18, then they would need to be disabled in some way, or otherwise they would not be considered financially dependent according to CRA rules. And then one other, a charitable organization. Interesting. A few years ago, Revenue Canada decided, hey, let's let people give their RRSP to charity if they want. So that's another way. And you could actually have your beneficiary be a charity. So who's a non-qualified beneficiary? Pretty much anybody else. Any child over the age of 18 that is able to care for themselves. So the result is that it becomes fully taxable in your state on your final tax return, in addition to other income that you would have. And then the beneficiary would receive the after-tax amount. And it's not usually a good idea to choose a non-qualified beneficiary as a named beneficiary. What do I mean? It's not good to choose one of your children over the age of 18 who is self-sufficient. It's not a good idea to put their name on as a named beneficiary. Why? Because the problem that could create is the money flows directly from your RRSP to that child immediately. And then 6 months, a year later, whatever, Revenue Canada comes knocking and asking for the money. Maybe the estate doesn't have enough money to pay the tax, and now they got to go chasing your son or daughter to get the money. Well, maybe they've already spent it. So you can begin to see that there could be some issues with this. So I don't usually recommend that you make your child a named beneficiary. You could make your spouse a named beneficiary. That's no problem. You can make a disabled child a named beneficiary. You could make a charity named beneficiary. But after that, then we should talk. Now, you could have something called a contingent beneficiary. What is that? Well, your spouse then would be the primary. If you have a spouse, your spouse would be your primary beneficiary or successor annuitant, depending on what you have invested in. And then you name a charity as a contingent beneficiary, meaning secondary. So the contingent beneficiary then would only kick in if your spouse has predeceased you, and that way the money would then flow directly to charity as a secondary beneficiary. Yeah, so maybe we should all go out tomorrow and check with our bank and put a secondary beneficiary on so that we could protect our RSP assets. Well, maybe you should, but maybe you shouldn't. And that's another reason I say work with one of our estate planners, because there may be other assets that would be better off to give than your RRSP. And then you could give your RRSP to your children without tax. So there's ways to work around that, but you probably could use some help. Well, what about power of attorney? Well, let's talk about it. Power of attorney, personal directive, depending on what part of the country you're in, you may have different names for it in your area, but it pretty much amounts to the same thing. So a power of attorney really enables the person to make decisions regarding their health care and medical treatment and hygiene and safety, and choose somebody to do that. You will need a continuing power of attorney also, or an enduring power of attorney, however you want to put that, because if you become incapacitated, then a power of attorney for personal care ends. And you would, so in other words, if you had a stroke, then you would need to have a continuing power of attorney. So here's a question for you. Have you identified what you'd want to be included as part of the work of your power of attorney? For instance, you could allow your power of attorney to manage all your property that you own, or it could be limited to some specific area, like maybe just your investments or something else, maybe some smaller part, or it might be your actual real estate that you'd want them to be in charge of. And remember this, power of attorney, personal directive, whatever you call it, cannot make a will. They can't modify a will. and they can't appoint a new power of attorney on your behalf. So there are restrictions on how far they can go. And you want that because you don't want them able to change capacitated in some way. Now, it would be important if you're having a power of attorney, and you should, to choose the right person. So is that person trustworthy? You need to pick some reliable. It helps ensure that your property is taken care of as you would want. Now, I see that again, but if it's getting choppy, I'm sorry, that's technology. Hopefully we'll persevere. And then your power of attorney. Will your power of attorney have time? You know, maybe their work is too heavy. And serving as attorney can take significant amounts of time. And you want to be sure that they're fully able to commit to looking after you or the property that you turn over to them. And is your power of attorney knowledgeable about financial and legal matters? Now, if they're not, are they able to learn about some of that stuff? But they should be knowledgeable about financial affairs to some extent, and some legal issues as well, because they have to make some educated decisions on your behalf when you're not able to. So again, it'd be important to have somebody. Now, you might be going, well, who could be my power of attorney? Well, it might be one of your children, or it might not. It might be somebody in a club you belong to or a church you belong to. Yeah, it could be some of those kind of things. And you may want to consider alternates. I would always recommend you consider alternates, because if something incapacitates you at a time when your power of attorney you had chosen is not available because of travel or work or whatever, it would be good to have an alternate. Well, I told you earlier we were going to talk about this, so let's talk a little bit about joint tenancy and the complexities of that, because I think it is an important piece for us to know. So joint tenants and tenants in common. You may often hear this, your lawyer may have spoken these words, you may have heard it at the bank, I don't know where, but I want to help you understand the difference. So what is the difference between joint tenants and tenants in common? Well, the main difference between the two is that joint tenants allows each owner to have an undivided interest, while tenants in common specifies the proportion of the property each person owns. Now, let me again put a disclaimer here. In Quebec, you're only allowed tenants in common. So the joint tenants, as far as I understand, is not used in Quebec. But the rest of the country, yeah, you could choose either joint tenants or tenants in common. So let me give you an example. Tenants in common is a form of co-ownership that allows multiple parties to own shares in a property. So let's look at it this way. Here's an example. Let's suppose John and Jane buy a house for $400,000. Jane pays $300,000, John pays $100,000. So if there are tenants in common, their agreement would state that Jane owns 75% and John owns 25% in this property. So that's what you have when you have tenants in common. It's divided in the ways that they have invested in it. However, both parties would have equal rights to use of the property and enjoy the entire property. So it's not that they can only enjoy 75 or 25. No, they can enjoy the use of the entire property. Tenants in common, when one of the parties in the tenancy dies, their share becomes part of their estate. So remember the John and Jane example? Jane would have 75% of that property would go through her estate, through her will. And owners can also sell their share at any time without the co-owner's consent. Now, I don't know about you, but if I were in a partnership like that, because that is kind of a partnership, I'd want an agreement that says what happens if you want to sell, or if I want to sell, or somebody wants to buy me out. So usually there's an agreement made between the two parties that if we want to sell, we have to have a first right of refusal to the other partner, for example, so that they don't end up in partnership with some guy or gal they never heard of before and didn't want to be in partnership with. So that's always a bit of an issue with tenants in common. But if all the owners agree to sell simultaneously, then the expenses and the profits will be divided according to the percentage that we talked about earlier and with John and Jane. So that's tenants in common. Now, joint tenants, this is the one you're probably more familiar with. Joint tenants are divided equally, their interest in and their right to possess the piece of property. So let me help you with that one a little bit more. Even though a joint tenant involves more than one person, the law treats it as a single owner. Now, that's a key issue because in a few moments, we're going to talk about how that could be a good thing or a bad thing, because the law sees it as one person, even though it's two owners. Now, each owner in a joint tenants agreement, they both have full ownership, and they have equal say on whether they would sell it or keep the property. So you can see that if it happens to be two people, they might get a split vote, right? And that could be an issue. Joint tenants is the most common choice when we're buying a property with our spouse. That's the situation that my wife and I have with our house, and also with our bank accounts. This is pretty normal with bank accounts, joint tenants. And then, however, it is becoming increasingly common as well for parents and children too. So depending on what it is that they own. So joint tenants continued. The primary distinction for joint tenants versus tenants in common is that joint tenants has a right of survivorship. So for example, our bank account says we are joint owners with right of survivorship. So it automatically passes to my wife if something happens to me. So as it says here, one of the co-owners dies, their ownership interest in that property dies with them. So I don't have the right to will that to somebody else. No, because my wife is co-owner with me, it would automatically go to her, and it doesn't have to go through probate and all those things. The deceased owner's shares do not become part of my estate, as I've already said, and instead, my wife would become the sole owner of that property. So when it comes to your estate, and we're talking about these tenants and joint tenants and all that, if you die and own a property with another party under joint tenancy, the survivor automatically acquires your interest in the property by right of survivorship. So that could be good or not so good. If you own this building together with another business partner in joint tenancy, then something happens to you, you don't have anything to leave in your will because it goes to the right of survivorship. Your interest does not pass through your estate, and it can't be left to a beneficiary you've named in your estate, but under tenancy in common, your share of that property would pass to the person you've designated in your will. So when it comes to our estate, there is a big difference in how these two things operate. And if you do not have a will, then the asset would go through probate and it would incur fees, and the laws of the region would dictate how that is to be distributed. Hopefully you have a will. Well, what about investment properties? This is kind of the last one of my section, and then we're going to turn it over to Mary Lynn in a few moments. But integrating investment properties into your estate, how does that look? Well, first of all, your primary residence, there is no tax, at least not so far in Canada, and that's good news because a lot of us that own our own home have a lot of capital gain built up in there, and that's a great thing. No tax. Rental property. So if this is an investment property, then there wouldn't be capital gains, less any adjusted cost base that you have for maybe repairs and stuff that you've done over the years that you owned it. But rental property is going to create a tax incident when it's sold. Next one would be vacation property, pretty much the same as rental property. I know some of you own property in southern climates, to get away from the Canadian winters, or you may own a cottage or a cabin in the mountains. Then that tax issue kicks in, and that's what I talked about earlier, when 70% of estate transfers fail. That might, some of them were because they had one of these properties, wanted it to go to the kids, but the tax on it was so great, they had to sell it to pay the tax, so that's always an issue. And of course, the tax has to be paid before the ownership is transferred to anybody else. So there's no transfer of this vacation property to your kids until the tax gets paid first. So investment property ownership, it is important to decide, if you're going to do it in joint tenancy, what system works best for any investment property. In other words, is it joint? Is it tenants in common, or is it joint tenancy? What's best? And if you buy a property with your spouse or a partner, you may pay tax on any increase in the value when you sell it, unless of course it's your principal residence, and then it would be tax free. If you bought the property for investment purposes with another party, each owner would then receive an equal part of the income earned, and their part of any increase is theirs in the property value. But here, watch this. Each owner should pay their own portion of the taxes payable. However, asterisk, since the law considers joint tenants a single owner, you could be liable for the taxes owed by the other party if they don't pay them. So that's why I say it's important, number one, it's important to decide which joint ownership you're going to have on this property. Is it tenants in common, or is it joint tenancy? If it's tenants in common, you wouldn't have that asterisk part as a problem, because it's the government CRA would see them as, you know, the example we had earlier, it would be like 30/70 or whatever. But if you do joint tenancy, then and the other owner doesn't pay the tax, your partner, you could find yourself having to pay those taxes. So very important as you're setting it up to make sure you do that right. So let me stop there and turn it over to Mary Lynn Huizinga, who, by the way, is one of our estate planners and is waiting to help you, I'm sure.
All right. Wonderful. Thank you so much, Lauren. Great. All right. So, engaging adult children and grandchildren. This can be very helpful in ensuring that your wishes will be honored. You see the first bullet point there. We want to avoid surprises. Surprises in the will don't tend to go well, right? You're the executor. Surprise! Your sister gets the cottage and you get the RV. Surprise! The best thing to do for a successful outcome is to have clear communication ahead of time to set expectations. You don't have to do a big reveal, springing the conversation on your family. You don't have to share any dollar values. Those are going to change anyway. But sharing your hopes, your heart, your general plan will go a long way to ensuring your wishes will be honored and your children can still be friends, or at least not dislike each other any more than they already do when all is said and done. So how can you facilitate that communication? Family meetings are a great way to build that connection. My family's in business together, and when we started our meetings over 20 years ago, we hired a facilitator, and it was invaluable. The facilitator set the agenda and promoted good communication. And for my parents, that allowed them to participate in the meetings without having to lead them. And with a neutral third party in the room to create that felt safety, difficult conversations were much more effective. We haven't always used a facilitator, but over the years, it has been helpful. Depending on your situation, You could also consider one-on-one conversations. Or even if having a conversation is impossible, consider writing a letter to share your heart and your perspective and file it with your will. This will go a long way to helping your family understand your love for them, your values, and the careful thought you put into your decision making. I should also mention that when thinking about your estate, you're not asking permission from your family. You have the decision-making authority and the responsibility to steward your assets. But if there is no communication at all, there will be surprises at the end of life. And typically, the only ones who benefit in that situation are the lawyers. How much better to intentionally plan ahead and communicate and get everyone working together as a family. About including your grandchildren. Well, this can be a great way to invest in them at a time in life where they have significant need, right? But we always have to keep your overall objectives in mind so we can look together at how to accomplish your goals. Perhaps you want your estate divided equally between your kids, a percent for charity, but you also want to give a generous gift of, say, $30,000 each to your 6 grandchildren, right? They're young adults just starting out in life. What a thoughtful gift. But keep in mind that in an estate, any liabilities must be covered first, and that includes the funeral taxes, any other amounts that are owing. And then the bequests are made, right? So now we've got 6 grandkids, 30K each. That's $180,000 gone. And finally, whatever is left and remaining is going to be divided between your children and that percent for charity we talked about. So this may or may not end up with the result you're aiming for, and we can talk about that. Another consideration is, might there be more grandchildren to come? If so, it's possible that additional grandchildren may feel resentment for receiving less of the estate, right? Especially if their siblings received something. Another thing to keep in mind is that if your grandchildren are underage, their inheritance will need to be held in trust. Minor children can only inherit up to $10,000 depending on which province you live in, which is a good thing. My 13-year-old daughter is into video games like Minecraft and Roblox right now, but those spending priorities will likely change over time. If leaving an inheritance in trust for your grandchildren, there are several things to think about, right? Who will be the trustee of the trust? When will the capital be paid out? If it's a significant sum, perhaps you'd like that capital paid out in stages, a percent at 18 or 19, right? Age of majority, another maybe percent at age 25, the rest at 30, right? You can think about that. And then you can also set conditions for distributions when you set up the trust. To incentivize, this could help incentivize desired behavior, right? Like pursuing education. But then you want to think about what you mean by education, right? What qualifies? Is it university, college, any other programs? Some conditions around life events, such as buying a first home, could also be in there, but take care not to be too specific so as to restrict the funds from ever being used. When considering a trust as well, remember there are costs associated with setting up and maintaining that. And a T3 trust income tax and information return must be filed annually, and the trustee is entitled to compensation for their work. So we can weigh out together the costs and the benefits. Is giving part of your legacy? I mean, we give back to society in many ways, and you're probably doing so even now. But is this something that will continue on your eventual passing? I mean, I think so. Everyone gives, right? The only question is how. Earlier, Lauren talked about, different taxes on our various assets, right? And that's part of how we give back to our society. But what if you could determine where those dollars were going and the effect they would have, right? If you could be part of that cycle of transformation that Stephanie was talking about. Um, you know, what a blessing to live in a country that allows us to offset our tax liabilities by donating to registered charities. So think about your values and how you can make a difference in your community and in the world. What are you already involved in? Would you like to make a one-time gift or create a gift that is distributed over time? So there are ways to accomplish your goals. For giving over time, in my family, my parents have set up a donor-advised fund with a public foundation, and I'm a part of that. And as we work together on charitable giving, they are passing along their values. I'm very grateful because I know that I can continue our family legacy of generous giving and pass that on to my kids over time. We talk about transferring values before transferring assets, right? Is generosity important to you? How can you share that value with your family members? Maybe give them opportunities to share your experiences so they can catch that passion. Recently, my parents wanted to do some giving while they're living, and they generously gave some money to each family member age 10 and up. And their request was that each of us would gift 10% to the charity of our choice and spend the remainder on whatever we choose. They were eager to hear our stories as we considered where to make our donations, and the whole family had the opportunity to share in the joy of giving. This might seem like a lot, but you're probably already doing this to some extent. So consider how you can be more intentional. It's not about demanding that your family adopt your perspective. That will not go well. But take your family along on your journey and allow them to catch your values. I was talking recently with a gentleman who manages the family foundation that his parents and grandparents established. And he's now working with his kids to continue the legacy of generosity. I asked him, how do you leave a legacy? And, a legacy of giving. And he replied quite profoundly. He says, you don't leave a legacy, you're not even there when this is happening. He says, it's not a one-time out of the blue thing. He said, what you can do is live a legacy. Then when you are gone, it lives on through the lives and the organizations that you have impacted. How do we navigate wills in the context of second marriage or blended households? Right? There's unique challenges here, because 2 or 3 or more individual family units are represented. So the needs of the surviving spouse and the needs of your children must be considered. Right? A friend of ours, his mom remarried and moved into her new husband's home where his children grew up. A number of years later, he passed, leaving everything to her. Problem is, her relationship with his kids isn't great, and she now has the authority to decide what will happen to their family home. This has not made their relationship better. If estate planning in a blended family is not handled well, mistrust, discord, and even legal tangles may develop between family members. So there are some things to consider. Is there a marriage contract or a prenup? My 86-year-old father-in-law just recently got remarried this spring, and we're so thankful that he and his new bride, they went to the lawyer, they got the prenup done, made their wills, and really looked out for each other and the family. One tool that blended families might use is a spousal trust. So the assets would be placed in a trust to provide for the surviving spouse while they're living, and at their passing, the balance would end up with your biological children. You could consider leaving some assets or special items to your biological children on your passing, right? That way they're not just waiting for your spouse to pass before they receive anything from you. You could also consider, when choosing your executor, maybe have your spouse as a co-executor with one of your adult children, right? So each family is represented, maybe more accountability that way. And another thing to do is make sure to review your beneficiary designations, right? Like Lauren was talking about, really important on life insurance policies or registered accounts. Consider the impact of what you have set in place and how it fits with the rest of your estate plan and make any necessary changes, right? I think of Margaret. Her spouse recently passed away, and she called the financial institution to start the process of rolling his RRSP over to her. Much to her shock, she found out he had not updated the RRSP beneficiary designation, and therefore the funds would all be going to his ex-wife. Even worse, the tax liability had to be paid out of his estate, reducing her inheritance even further. Hardly the outcome her husband anticipated. We also must remember to plan for our care while living. If something happens to you and you lose capacity, who steps into your shoes, right? Like Lauren was talking about, to take care of your financial affairs or make your healthcare decisions. Without a power of attorney or personal directive, it gets very complicated in a blended family, right? Who will make those decisions? Will it be your current spouse or your adult children? Will they act in accordance with your wishes? And what if they can't agree? How much better for everyone if you have the conversation ahead of time, set expectations, and communicate your wishes. This will go a long way towards family harmony and peace of mind for your family in what would be a very difficult time. Lauren, over to you.
I'm coming. I'll get there. So let me just share a few things with you. So now what? I say now what? So now that you've been listening to all of this for the last 45 minutes or so, just remember about the 70% of the states fail. We don't want that to happen. We don't want that to be our situation. Advisors with Purpose are here to help you. We have
Lauren,
professional.
sorry, Lauren, I'm just gonna have you turn off your camera if you don't mind. You're pixelating again, and we'd rather have the information shared. So if you don't mind turning off your camera for a second, please.
Yeah. Hopefully that will help. I don't know. So it would be, we're here to help you. That's what we're here for. So take advantage of that opportunity. There is no cost to you, just as a reminder, because of the sponsorship with Opportunity International, and nobody's going to try to sell you anything. So here's how it works. We want to help you make better decisions so your family will live with fewer disappointments. So within the next few days, we will contact you. So Tanya Rust at Advisors with Purpose will reach out to you. You'll notice her email address there. That's what it looks like. So when you get an email that says trust at Advisors with Purpose, that's Tanya Rust sending you an invite to have a one-on-one consultation with an estate planner. All the meetings are by phone or Zoom, so you don't have to go anywhere, and nobody's coming into your home. It just makes it very easy for everybody. It's a simple 3-step program. The first one is just getting to know you, how many kids, grandkids, where they live, that kind of information. The second one is more into, do you own your home? Do you have RSPs? Do you have tax-free savings accounts? Those kind of questions, so we can figure out the tax implications. And then helping you implement your plan. Yeah, coming back to you and working with you to say, is this solve what you wanted? Does this get you where you want to get to? If not, we'll rework it until it does look like what you want. So here's how it works. It's confidential, always confidential. No information that you share with the estate planner is ever going to be shared back with Opportunity International. That's not what we do. It's confidential. We'll provide you with your own personal estate plan. And we just want to help you think through the preparation for your will. Preparation is around those issues that we've talked about today. And you can be assured that we will focus on the most tax efficient method. So I'm about to go to questions, but before we do that, I would like Stephanie to come back. Oh, maybe just before that, sorry, Stephanie, I jumped the gun there. So if you're feeling like, okay, well, I don't want to have to, it's too expensive to go to a lawyer. My wife and I went to a lawyer, had our wills redone. I always recommend that. If you find that that's out of your price range, well, you could use this. So here's a Canadian Legal Wills. So it's their email address is there. It's just legalwills.ca. And if you put /AWP afterwards, you get a lower price. So that's why it was, you see the line $39.95 knocked down to $27.97. You can actually prepare your will there very inexpensively. You can do a double will for like $60. So a will for you and your spouse. So that's there. And I just wanted to share that with you in case you wanted to use that. And Stephanie, over to you. You're still muted, Stephanie.
Thank you, Lauren. That's great. I'm glad you added that in there, and that's a very reasonable will. So thank you for including that. Mary Lynn, Lauren, there was so much, so much value shared tonight within your presentation. Thank you for your expertise and your interest in helping individuals make sense of this complicated and very important part of life. I did want to be sure to mention that the opportunity to work with AWP is available not only to Opportunity supporters, but also to your friends and family. And it is complimentary, it is confidential, and with no obligation to support OIC, and with no sales pitch attached. As Debbie mentioned, you will receive a recording of the webinar. Please do feel free to forward it along to anybody in your circle who could benefit from the information. I can say from my own personal experience that this is an incredible opportunity that truly can provide you peace of mind for your future and those that you care about the most. We are so grateful for all of our participants who joined tonight, and we really do appreciate you taking the time. Thank you so much.
Thanks, Stephanie.
Great, great. Thank you, Stephanie, so much. Thank you, Opportunity International Canada. We do have one question here that came in, and maybe there'll be more. So use the Q&A if you don't mind, that box that says Q&A for your questions. But here's the first one, Lauren. I think this was in your area. The person said they missed the first little bit. So they'd like more clarification around your children being taxed on our RSP. So if they put their children on their RSPs, can you explain that a little bit again?
Yeah, so of course, outside of Quebec, I'm talking about, so Quebec is different, but if you're living in any province other than Quebec, you would have a named beneficiary on your RSP or RIF. And I said, if you make it your children, unless they're disabled, then it would be taxable to your estate. And I think Mary Lynn gave a really good example of that with a second marriage, but even with the first marriage, if a person has their spouse as their beneficiary, that's good. But if they name their child as a beneficiary, then it's going to have to be tax taken out of the estate. So I remember one case that we heard about. We didn't get to work with this person, or we could have solved the problem, but this mother had three daughters. She had named the three of them equally in her will, but her RSP was named beneficiary to one of her daughters. Well, the one daughter got the RSP, and that was the major part of the estate. There wasn't much else there. So the other two really didn't get anything. And then, so they're not very happy, of course, because they're thinking, well, we should be sharing in the RSP if that's all there is. But because it was a named beneficiary, it overrides the will. So it was not available to the will. Now, here's the other second part. A year and a half later, Revenue Canada came looking for the tax on the RSP, and her estate, of course, couldn't pay it. So the daughter had to pay it. So it's important to make sure we have the beneficiaries correct on things like RSPs that have the high tax. If you want to give something to your kids on a named beneficiary, tax-free savings account would be a great thing to give.
Good, good. another RSP question, and so Mary Lynn, if you want to tackle this first, and you can pass it on to Lauren, whichever you'd like. Are qualifying charities that are beneficiaries of RSPs taxed on the total, or is it transferred tax-free to them?
Great question. Yeah, that's going to be transferred tax-free to the charity, and your estate will get a tax receipt for that donation, for the value of that donation. And because of that tax receipt, donation tax credits will be generated that would likely offset or very close to offset the tax liability associated with that RRSP.
Excellent, good. Well, I think we are out of questions, and actually we've taken up everyone's full hour of time. So I just want to say thanks again to Lauren and to Mary Lynn. Thank you, Stephanie, for your great information sharing about Opportunity International Canada, and thanks for inviting everyone to join us this evening. So a couple of things: look for the recording in your inbox yet this evening. You look for your email from Tanya Rust, and there's a 2 really short, quick question survey that's going to happen as you exit. We'd really appreciate you taking the time to do that and fill it out, so it gives us feedback, so we know how to best relay this information to you in the future. So thanks, everyone. We appreciate you taking the time, and we'll be in touch. Thanks so
Thank you.
much.
Bye.
Bye.
All right, bye-bye.